Good afternoon, everyone, and welcome to Deloitte's Dbriefs Tax webcast series in Asia Pacific. Our webcast today is from our corporate income tax series and is titled Compare and Contrast the Software Copyright Treatment in Australia and India. My name is Neil Pereira and I'm a tax partner based in Deloitte, Australia. I have the pleasure of hosting today's webcast. I have two guest speakers with me today, Sharath Rao and Rachel Siasia. Sharath is a tax partner based in Deloitte, India, and Rachel is a legal partner based in Deloitte Legal, Australia. Just a little bit of housekeeping before we start our presentation. You may access our bios on the left side of the screen, and I'll also highlight some of the features of our webcast console. Firstly, all users are on listen-only mode. If you have any content-related questions, you can submit them at any time in the Q&A box at the bottom of the screen, and we'll do our best to respond to your questions during the presentation. Secondly, all PC users can maximize or minimize each box at your convenience during the webcast. You may also explore the icons at the bottom of the screen. If you want to download today's slides and related publications, please go to the Downloads and Links box. On the other hand, mobile device users can view the slides and answer the survey questions on the screen. Thirdly, if you require an attendance record for the event, you can download your CPE certificate by clicking the Request CPE icon at the bottom of the screen. Now, let me give you a brief overview of the topics we'll discuss today. We'll cover both the Australian and the Indian context. For the Australian context, we will go through a few things. There's a new taxation ruling, TR 2021, in draft that's been released for comment. We'll also compare that to the old ruling that's been around since 1993, TR 9312. We'll go through some examples in the new ruling, as well as discuss some legal issues associated with copyright, the tax office's view, the Copyright Act, and we'll conclude with implications for clients. In the Indian context, we'll go through the recent Supreme Court case and look at the categories covered by the Supreme Court judgment, as well as the interplay with the Indian Copyright Act. We'll also review the position under the Double Tax Treaty and OECD guidance, and we'll also look at new legislation in India around the Equalization levy on digital goods. And we'll also address implications for clients under that section. As an overall conclusion, if there's time, we'll go through Q&A from the audience. So before we begin, I'd like to just go through our first polling question for today. Which of the following jurisdictions do you see tax authorities taking an expansive view of transactions that would be captured by royalties and consequently subject to withholding tax? You'll have these options to respond in your screen. And whilst we're waiting for the results to come in, I'd just like to maybe ask a question for Rachel. Now, Rachel, I guess some of the trends we're seeing is it's really important to identify the relevant intangible asset or transaction with specificity, as there may be significant tax or transfer pricing implications. What are your thoughts on this?
Thanks, Neil. Yes, it's certainly becoming of increasing importance, particularly in Australia with the release of a new PCG around intangible arrangements. So this will affect all companies with international intangible arrangements in Australia. And if it's finalised as it's currently drafted, that PCG will have quite a high burden on taxpayers to analyse and document and identify with specificity those intangibles, and this is the broad definition of intangibles, not just IP, as that will impact on their transfer pricing aspects between their related party transactions around those intangibles and ensuring of compliance with those requirements on reporting on those intangibles from a tax and a corporate governance perspective.
Thanks, Rachel. And we can see from the responses to the polling question a reasonable spread, and authorities kind of in general probably are creeping into the expansive view of royalties and withholding tax. That's good to know, as that sets up the context for our presentation. We'll continue with the slides. For the first part of the presentation, we'll review the Australian context. So as I mentioned, there's a new taxation ruling out in draft, TR 2021/D4. and our pre-existing ruling, TR 9312, was withdrawn. The new ruling seeks to address changes from technological changes. Basically, at the time the old ruling was released, software was typically released on physical medium, so CDs and then DVDs. The new draft ruling by the tax office seeks to capture modern methods of software distribution, being cloud software and SaaS products and services. The new ruling is meant to have both retrospective and prospective application before and after 1 July 2021, the date that the old ruling was withdrawn. Now, the tax office has put out submissions and obtained those submissions. And one of the things it's going to be looking at, we understand, is the application date of this new ruling. The old ruling still applies prior to 1 July 2021, and it still protects taxpayers to the extent that they've been relying on this old ruling. Next slide, please. So just a bit of a context around royalties in the view of the Income Tax Act. This goes back to our 1936 Act. And I'll leave this on screen, but I'll just talk really briefly about the key things that are relevant for today. So royalty or royalties, as defined, includes any amount paid or credited, however it's described or computed. And importantly, under subsection A, it includes the use of or right to use the copyright, amongst other things. And for sub C, it includes the supply of relevantly information by way of the source code. It also includes some other aspects, including supplies that are ancillary to the original copyright. Next slide, please. So I'll just go through some of the views that have come out of the earlier ruling, and what this means, or what this has meant when looking at it in the context of copyright in software. So previously, a payment was considered to be a royalty for the purposes of the Tax Act, where the payment was consideration for the granting of a license, importantly to reproduce or modify the computer program, without which this would lead to an infringement of the copyright. So part A of the definition of the royalty that we saw in the previous slide. It also included consideration for the supply of information by way of know-how, paragraph C of the prior definition, which includes the supply of the source code, as I mentioned. Notable exceptions in the prior ruling, importantly, were payments for the granting of a license which allowed for what was referred to as simple use of the software, i.e., it allowed the end user simply to run the software either on a single computer or on a network, but otherwise didn't permit any use of the copyright in the program. And that's the distinction that's drawn in the old ruling. And Rachel will touch on this a little bit more, but the distinction is essentially drawn between the use of the software versus the use of the copyright in the software. The other exceptions are relatively clear, where there's a sale, involving the transfer of all ownership rights of the copyright, sale of goods where the copyright is integrated into the hardware, a computer, laptop, or desktop, and services that are ancillary to the simple use of the software. I'll pass over now to Rachel, who will take us through the next couple of slides. Thanks, Rachel.
Thanks, Neil. So if we looked at the next slide, when we're concentrating on the use of copyright under the existing ruling, which Neil just discussed, it's very practical and gives us very clear guidance around, it's concentrating on the reproduction and modification rights, which would otherwise constitute an infringement if there was no license. So this is how, as intellectual property lawyers, we would be thinking about when we're granting a license, that it's only necessary in the event that the person wouldn't ordinarily infringe on those rights without that. Importantly, in this ruling also, it mentions the ability for a distributor to act as the agent, or essentially stepping into the copyright owner's shoes in relation to selling software programs to the end user. So those sales won't necessarily be caught by as a royalty. Now, in many distribution agreements, the concept of agency from a legal perspective has a different meaning and will often be specifically excluded from distribution agreements and noted there. So that's something to bear in mind when looking at your distribution agreements under this existing ruling, whether you've specifically excluded agency. And as Neil mentioned, this ruling was very much focused on the older style of the way software was acquired and distributed in the form of a CD. Whereas if we look at the new ruling under the next slide, please, the ATO has really taken an expansive view and looking at if it's any grant of a right to do something, which is the exclusive right of the copyright owner. Now, from a legal perspective, the way copyright is applied is that there is, in Section 31 of the Copyright Act, a range of exclusive rights that are granted to the copyright owner, which includes the right to enter into a commercial arrangement. Then much of the rest of the Copyright Act, there's several provisions which go into detail around what acts do not infringe the rights of the copyright owner. So if we just looked at what is defined as the exclusive rights of the copyright owner, we could actually bring into this arrangement what would not, had we had all of the exclusions that we'd have in the previous ruling where it didn't otherwise infringe, could now be caught. So where we need to be particularly careful when looking at this ruling is that those distribution arrangements where there's cloud and SaaS products, where the distributor is now going to be looking at just allowing the end users access the platform but may not own the platform itself, how carefully we need to contemplate those arrangements under this new ruling, as the exceptions that are included in the new ruling do not cover off all the exceptions that are in the Copyright Act. So there are the exceptions where the simple use rights, so rights which don't allow sub-licensing are not included, or the distributor, as we've got in here, does not obtain any rights in relation to the software that is exclusive right of the copyright owner, which again, as I mentioned, is quite broad. So if we move on to the next slide, I'll hand back to you, Neil.
Thanks, Rachel. So we'll just quickly compare the old ruling and the new ruling and some of the wording and concepts there, and really follows on from what Rachel said. If we look at paragraph 29 of the old ruling, we look at payments for a license for simple use only of computer software were not considered to be royalties, irrespective of whether the software is acquired by the distributor for sub-licensing to end users or by end users directly. So that allowed essentially us to look at a distribution model and for the distributor to provide a license to end users. Now, there may have been some context around prepackaged software where you automatically enter into a EULA when that packaging is received or opened. Neither the software nor the packaging itself or the CD itself was ever the property, technically, of the end user. And we compare that now with the new draft ruling contained in paragraphs 75 and 76. A payment by a software distributor for the right to sub-license the use of software is a royalty. And that's regardless of whether that's in physical media, digital or cloud, or even software as a service context. So it also incorporates the case where the payment by the distributor is for the right to grant the simple use of the software. So clearly a distinction is being drawn between the old ruling and the new ruling. And as Rachel said, it's a more expansive view. And that's because, again, that we go into paragraph 76, that's because the payment is considered to be royalty because it's for the right to do something in relation to software that's the exclusive right of the copyright owner. And it incorporates this view that we're doing something that involves the copyright in the software, not just the software itself. A small point is that the comments on trading stock and inventory have been removed from the ruling, and there's in the ATO's use substantial guidance elsewhere on these aspects. So we'll just move to the next slide, please. So in here, we'll just look at some context around the examples that are provided. And I should probably say, based on submissions received to date, which are now closed, the ATO is considering. They have mentioned that more examples are likely to be provided when the ruling is released in final form. So we see here some points that I've just highlighted. Software distribution, where it confers the right to enter into end-user license agreements, or EULAs, between the Australian distributor and the Australian customer, now would likely fall within the definition of royalty and be subject to withholding tax for payments by the distributor overseas. And in a similar scenario, distribution agreements where we've got a cloud services SaaS model would also fit within this. And Rachel would explain some of that a little bit more in her slide coming up. Where these arrangements are not going to be seen as a royalty, pure licenses for the simple use of software, distribution agreements not conferring copyright, or ancillary services. And one of the key themes coming out of this is the local EULA. So if there isn't a local EULA between the distributor and the customer, then arguably in the context of the new ruling, that is not likely to be a royalty. If we move to the next slide, please, we'll just go through some examples. And I won't go through this verbatim in terms of what we are presenting on the slide. You can look at that at your leisure. But just some of the compare and contrast between where the payments are seen as being subject to royalty and where they aren't. So the clear case of a license for simple use not being subject to royalty withholding tax is where we've got the overseas provider or copyright owner entering into service agreements or end user license agreements directly with the user entity or individual in Australia, where the software provider is overseas. Whether this is a monthly payment for a service or an annual license fee, this won't be seen as a royalty where it's licensed for simple use. The other two examples, example 4 and 5, broadly capture the scenarios where the Australian entity is the distributor in question, either distributing the software or providing service rights to the end Australian customer. And there are two sets of payments in both examples. I'll just sort of talk about them as one. The Australian distributor will make a payment to the software provider overseas, and the Australian customer will make a payment to the Australian distributor. This could either be for the use of the software or for cloud services. And importantly, in these scenarios, notwithstanding, even in example 4, the distribution agreement doesn't permit the software to be reproduced or modified, because in both scenarios there is a end-user license agreement or a cloud services agreement, subscription agreement between the Australian entity and the end customer. These would be seen as being subject to, being characterized as subject to royalty withholding tax by the ATO. So just moving to the next slide, thank you. I'll hand back over to Rachel to take us through the views on copyright and copyright law.
Thanks, Neil. So when we take a copyright law analysis to the ATO's draft ruling, and in particular its explanation around the draft ruling, the ATO has brought into play this right to communicate, which is in the Copyright Act, but it's applying it to a software context. So it's using more of a case law around artistic works, not literary works, which is the case for software. So the way that the ATO in its explanations and explaining this is that if this was applicable, we're looking at does the distributor own the platform? Is it making the software available? And is the software being communicated to the end user, in which case the end user's got the end user license exemption, but does the software, the distributor making that platform available, and who controls that? For example, who's issuing the access key and whose terms and conditions are those end users applying to or complying with? So if we're looking at that right to communicate, that will also apply in where the software is downloaded. So is the software downloaded from the distributor, or is it downloaded from and made available by the copyright owner? So one thing I think in the submissions or that have gone back to the ATO, and certainly what is being clients are bringing up with us, is around that distribution arrangement for software platforms like SaaS arrangements and cloud service arrangements, whereas copyright lawyers, a distributor would not necessarily be needing a license to facilitate that sale, whereas when we're looking at this new analysis and in the ruling, it does take, again, as I mentioned before, quite an expansive view, which we would normally see other sections of the Copyright Act, particularly temporary reproduction, as part of a technical process or use, exemptions that apply that aren't incorporated into this new ruling. So I do think that there's significant grey area that would require further analysis, and particularly close look at the distribution agreements that are in place between companies cross-border. I'll hand back to you, Neil. Thank you.
Thanks, Rachel. I think we can skip to the next slide, please. So we'll just quickly do a wrap-up of this section. I think the key things are, this is a draft ruling from the tax office. So important to note that that means that it isn't law, it's the ATO's view of the way the law operates. And it is open to interpretation and challenge as well. The tax office have taken submissions, and we're expecting a finalized version of the ruling to come out early in 2022. Some things for us to consider. How does this new draft ruling, how will it interact with the tax treaties? At the end of the day, if the tax treaty sets out a certain view with respect to another jurisdiction, you would think that that treaty view should prevail. And the ATO has received submissions on this and will provide guidance. The key risk there is that we have a mismatch that somehow needs to be settled because it gives rise to double taxation. And then you enter into quite a process through the treaty to relieve that double taxation. Another interesting implication, which is difficult for clients, is where in the Australian context, the MAL rules came in and required effectively a lot of companies to restructure and to enter into local contracts. So where these came about in the context of software distribution and local end user license agreements were brought into play, this could very well mean that those arrangements are now subject to withholding tax, even though they're MAL compliant. And the terms, as Rachel said, it's important to look at the terms and conditions and language of the agreements to make sure you know where you stand. There could be financial statement implications arising from this for uncertain tax positions. And I've mentioned the legal consideration. Interestingly, in bringing out the ruling, the tax office has indicated that they haven't as yet looked at significant legal advice or input outside of the tax office into the Copyright Act and into the legal aspects. So this presumably could provide an opportunity to distinguish company cases from the ruling, or provide grounds for arguing that the ruling shouldn't apply. But we may well see that coming into the ruling from a legal position early next year. Obviously, there are implications for transfer pricing as well, because not the whole of the distribution payment out from the Australian distributor to the copyright owner would be a royalty. There could be payments for other things in there. So bifurcation of those charges between services, royalty, and other things may be required. And that's not contained within the ruling itself. So I think that's probably all we want to cover in this section. Before we move to the next section, which is the Indian context, we'll just go through our second polling question for today. The question is, how do you see tax authorities around the region considering the OECD views around software copyright treatment and royalty taxation issues? Basically, is there a high alignment to OECD, a medium alignment, neutral to low, divergent, or don't know, not applicable? And while we're waiting for the results of that polling question to come in, we'll just go to a question to Sharath. Given that there are a lot of such issues which are cross-border, and any mismatch with tax authorities could lead to double taxation, how important, Sharath, would you say it is to achieving consensus? And why do you think countries are taking a unilateral approach?
Yeah, thanks, Neil. Yeah, I think it's important that two countries arrive at a consensus sooner than later, because these are evolving issues. As technology evolves, so will the taxation law and also the copyright implications. And it's not feasible or practical that every time there is a dispute between two countries that they end up in having a mutual agreement procedure, because MAP, as we know, takes its own time, and it's fairly expensive and time consuming, and it's not practical that we resolve these disputes through a MAP process. And therefore, I think it's very important that countries try and set out the base principles around these payments in relation to software or more recent way of transacting in the form of cloud-based services or SaaS-related products. On your second question, why are countries resolving to unilateral measures? I think as we see, the OECD and the inclusive framework has come up with action plans. It is taking time to arrive at a consensus. And in the meantime, countries, especially market jurisdictions like India, they do not want to wait until there is a consensus and lose out on the revenues. So they are trying to come up with unilateral measures, primarily to try and get more revenues until there is a consensus. So that's the way I see it.
Thanks, Sharath. And I see the results of the polling questions that have come in. I would say there's generally an even spread, but there's a good deal of medium-level alignment we can see there. So that's good to know, and sets the context, I guess, for this topic. Sharath, I think we're going to talk about the Indian context now, so I'll hand over to you.
Yeah, thanks, Neil. Yeah, so the Indian context is, it has a long checkered history, as most of us would know. Just as a context, the royalty definition in the domestic tax law recognized computer software for the first time in the year 91, and the copyright law recognized software in the year 1994. So we've been seeing litigation around the tax characterization of software payments right from the late 1990s. The Indian tax office view always was that any payments towards import of software for simpliciter use amounts to a royalty, whereas the taxpayer's view was that it is not royalty, and we are just importing software for using it, and therefore it is akin to goods. Now, the revenues position was based on the definition of royalty in the domestic tax law, which said that payment of any consideration towards transfer with respect to copyrights, including granting of a license, amounts to royalty. And therefore, they thought that since a software is permitted to be used through an end user license agreement, there is invariably a license that is involved, and therefore in their minds involves the use of copyright, and therefore it was royalty. And even with respect to the double tax treaties that India had entered into, the revenues view was more or less similar, that it amounts to royalty. So this case reached the Indian Supreme Court for the first time in the year 2010, roughly after about 14, 15 years of litigation. Now, unfortunately, in the first round, the Supreme Court could not deal with the merits of the issue, because all that it had to see is whether every import payment required withholding, and it said no, and it sent the case back to the High Court to decide. And later on, sometime in 2012, we had a second round of decision from the High Court, wherein the High Court confirmed the revenues view, and this was the Karnataka High Court, that it amounts to royalty, whereas we had other high courts like the Delhi High Court, which emphatically said that these payments are not royalty. So we had a divergence of views from the High Court, and therefore it was high time that the Indian Supreme Court decided this issue. And we did get a ruling from the Supreme Court in 2021. And the court was looking at a bunch of categories involving software payments. It was looking at about roughly 86 appeals. Category 1 was end users of software. Category 2 was Indian distributors who purchase software for onward sale. Category 3 was overseas software vendors who in turn could have been distributors themselves directly selling to Indian end users. And fourth was a category of software loaded onto hardware, where there were foreign companies selling hardware like telecom equipments, which comes along with software to enable use of software. Moving to the next slide. Now, vis-a-vis the main point or the main argument on the revenue was that there is an end user license agreement using which the software is sold by the vendors to the end users. And since the end users sign on the EULAs, it amounts to being given a license over the copyright of the software. So be it that it is just simpliciter use of software. In their mind, they thought that end user license agreement clinches the position for them that the payment towards use of software is royalty. Now, in the context of distributors, again, the Indian Revenue's contention was that under the Indian Copyright Act, Section 14 to be more precise, they thought that since the language said that allowing sale of a copy of a computer program amounts to use of copyright, in their mind, since the distributors were selling copies of software, they thought that even the distributors were being allowed to exploit the copyright in the software, and therefore the payment by the distributors is also payment in the nature of royalty. Now, these were the key arguments. Now, therefore, the Supreme Court had to look at the Indian copyright law and to see in what context is granting of a license used. The court said that as per Section 30 of the Indian Copyright Act, a license over copyright means a license granting an interest over the copyright, interest in any work in the copyright. Then they compared this with the language used in the end user license agreement, and they found that most of the end user license agreements merely allowed the user to use the software, and while there were negative conditions or negative covenants, that was preventing the user from making copies of the software, from adapting the software for something else, or for redistributing the software. So these were just negative covenants. But the main subject matter of the end user license agreement, as the Supreme Court saw, was merely enabling the user to use the software, nothing more. And therefore, in the context of end users, the court said that just because there is an end user license agreement, that does not mean that the payment made by the user amounts to use of copyright in the software. He's just using the software. It is akin to goods. Now, coincidentally, the same Indian Supreme Court a few years back, in the context of the Indian sales tax law, which is now the GST, had held that software is goods under the Indian Constitution. So the Indian Supreme Court in this case was relying on that judgment to also say that once it is held to be goods, then the same character has to be carried forward even in the context of determination of withholding tax. Especially so where the EULAs don't give any sort of right over the copyrights to the user. In the context of distributors, again, what they said is that the way we have to read the right given to someone to sell a copy of the computer program is only in the case where somebody is given the reproduction rights. For example, if the distributor is given a right to reproduce copies of software from a master copy that has been given to him by the original software vendor, and from those copies he makes sales to the market, then only then in that case will it amount to a copyright right being given to the Indian distributor. Otherwise, in most of the cases that the court saw, all that was happening was that the distributor was only buying copies of the software and onward selling the same copies. So it was like a buy and sale, like a trader. So they said that there's no copyright being given to a trader. So in that context, the court emphatically said that when somebody looks at the Indian copyright law and sees what is the nature of a license, compares that with what is the license agreement all about and what is the distribution agreement all about, in the context of the 85 odd cases that it saw, it concluded that there is no copyright rights being given either to the end user or to the distributor so as to treat the payment from the distributor or the end user being royalty. So therefore it said that no withholding tax. Moving on to the next slide. So the second aspect that the court looked at, since India also has a treaty override principle, the second aspect that the court looked at is what is the definition of royalties in the double tax treaties. And like in the case of the Australian domestic tax law of 1936, even in the treaties, what the court observed is that most of the Indian double tax treaties have borrowed the language from the OECD model, wherein the royalty definition is worded in such a way that only where the payment is for the use of copyright as opposed to just using a copyrighted product like a software. So only where the payment is for use of copyright will it amount to royalty. And this is something that the court noticed was the language in most of the double tax treaties, whereas in some of the more recent double tax treaties that India has entered into, the court did notice that in those treaties, the royalty definition specifically referred to the aspect of use of software itself being amounting to royalty. And in those treaties, the court said perhaps in those cases it may amount to a royalty, but not in most of the other treaties where it has to be payment for use of a copyright for it to amount to royalty. Even in India, computer software is treated as literary works. And therefore it said that we are inclined to borrow the OECD commentaries for interpreting the double tax treaties, and therefore in our view the double tax treaties will override the Indian domestic tax law. In fact, the court also noticed that up until the 2012 amendment by the Indian government amending the definition of royalties, the court felt that up to 2012 the Indian domestic tax law definition also did not allow the government to tax this as royalty, and that was the case similar with the treaties. And it's only after the 2012 amendment where there was an explanation introduced in the Indian domestic tax law to say that mere use of software itself would amount to royalty. The court said that maybe only from that year will it amount to royalty. Nonetheless, since the treaties have been unchanged, there is no amendment to the treaties, a unilateral amendment cannot override the treaties. And therefore, the court concluded that even to date, the treaty definition will hold good, as per which the payment towards simpliciter use of software or a simple distribution of software buy and sale will not amount to royalty. Moving on to the next slide. Yeah, so that was about the Supreme Court ruling. So just to summarize, today under the Indian domestic tax law, payment towards simple use of software or payment towards buying of software for onward sale doesn't amount to royalty. Now, interestingly, Indian government introduced equalization levy in 2020, and we call it EQL version 2, because there was a equalization levy introduced in 2016, which was more targeted at taxing online advertisement revenues. In 2020, the scope of equalization levy was expanded to cover sales by e-commerce operator for any online supply of goods or online sale of services. If e-commerce operator is engaged in an online supply of goods or online sale of services through any electronic or digital framework or platform, then that amounts to that gets attracted within the scope of equalization levy. Equalization levy is a levy of 2% charged on the revenues of foreign companies or foreign e-commerce operator from the sale and supply of goods and services. Now, in the context of equalization levy, equalization levy is something which is a sort of a byproduct of the Action Plan 1 in relation to addressing tax challenges in relation to digital economy. So this, the genesis of equalization levy can be found in Action Plan 1, and India has gone ahead and introduced this. And the stated position of India is that once there is a consensus, perhaps this levy will be withdrawn. But currently this levy applies. Now, what is to be noted is that this levy is irrespective of whether there is any copyright usage or it is simpliciter use or it is use of copyright, it doesn't matter. The moment there is an online supply of goods, for example, if a software is sold by a foreign company through its own servers and where the users are allowed to download the software and then it is put on-prem by the user and used, that could bring the overseas foreign company to this equalization levy. So this is a new development. So even if there is no withholding tax that is applicable by reason of the Supreme Court ruling, this levy is something that is now applicable. Moving on. Now, what are the implications for clients? Now, if you look at the Supreme Court ruling, there is a lot of emphasis by the court on the manner in which the agreements are written out, and therefore it could be a fact-based determination of whether there is any copyright rights given to either the end user or the distributor, specifically in the context of the sub-licensing right, which has become quite prominent in the new ruling that is issued by the ATO, where they believe that when a sub-licensing right is given to a distributor and the end user license agreement then becomes a local agreement between the Australian distributor and the Australian end user. As per the new ruling, it amounts to use of copyright, and therefore the payments from the distributor to the overseas software owner amounts to royalty. Now, in the context of the 85 odd cases that the Supreme Court reviewed, they did not find any of the agreements having a sub-licensing right to the Indian distributors. But the court did make an observation in passing that since there is no sub-licensing right given to any of the Indian distributors, it cannot amount to royalty. So one way to look at it, therefore, and definitely with the development in the new Australian ruling, this is something that one has to watch for. And at least in my experience, I have seen a lot of practical situations where the EULA happens to be a local agreement between the user and the Indian subsidiary of a foreign group which is selling software. In some cases, it is a direct EULA between the Indian user and the foreign company, whereas in some cases, the EULA can be local as well, which means the Indian distributor has been given a sub-licensing right. Now, typically, many companies tend to do this for various reasons. One of the reasons could be that if there is any copyright-related breach or copyright-related litigation, then perhaps they don't want to involve the foreign parent in the local copyright litigation and let the Indian subsidiary deal with it, because it is the Indian subsidiary which has signed up the local agreement of EULA. But we have to be mindful that the question is, will this sub-licensing right amount to use of copyright right, and therefore will the payment by the distributor to the overseas parent, will it amount to royalty, and what part of it will amount to royalty? These are some of the nuances which will come. And of late, we have been seeing the Indian revenue officials reviewing the agreements in quite a bit of detail. So this is something that we have to be mindful of. And of course, equalization levy is something that we also need to look at. Now, both equalization levy and withholding tax are mutually exclusive. The law says that if withholding tax is applicable, then by default, no equalization levy applies. So equalization levy would come into picture only where one can conclusively say that there is no withholding tax applicable. On a practical note, despite the Supreme Court ruling, the Indian Tax Office may still want to evaluate if there is any withholding tax leakage, because Indian withholding tax is about 10%, whereas the equalization levy is only about 2%. So that's about it from India. Neil, back to you.
No, thank you, Sharath. That was really interesting. What we're going to do now is probably move to some Q&A, but I think the points you mentioned and going over the case really have some interesting resonance when you look at it, because it seems very much a purpose of interpretation was taken by the courts without getting necessarily drawn into the technicalities, perhaps, or nuances of Copyright Act and things like that. But there does seem to be quite a distinction anyway between India and Australia in terms of how you look at some of those. But clearly, when you look at that and compare the Australian context, it's a very expansive view taken by the tax office on the one hand. And you mentioned the EULAs and what the examples were that were looked at. And I think so if there were examples, even if there were examples of local EULAs in place between the Indian distributor and customers, what would it be the likely outcome in terms of the court's view on that? How do you think that would have gone?
Yeah, that's quite interesting, Neil. Like I said, the court did not have an occasion to review structures where there were local agreements, but I think it did make in passing reference that there are no sub-licensing rights. So I think that aspect, in my view, is still open. And while the court also said that one has to look at the substance and not the form, and therefore, even if some minimal rights are given which appear to be rights in the nature of copyright rights, perhaps the court would have come to a conclusion that in substance this is just purchase and sale of goods. But in my view, this aspect of local EULAs and sub-licensing rights is something that can lead to another round of litigation in India, especially with the ATO now coming up with this view.
Thanks. I see there's another question through the Q&A around approach to this sort of issue around royalties, where you've got streaming services. And I guess I would say the controversy with copyright in the context of softwares is probably a little bit grayer, because is it or isn't it a breach of copyright? And views have been quite fluid. But the tax office taking more and more of an expansive view. So maybe not as clear cut as in other cases. But Rachel, maybe I can get you to comment on this around, royalties in the context of streaming versus, royalty as we discussed in the context of software distribution.
So I think, Neil, you're cutting out a bit there, but I think you're asking the context of the copyright in streaming services. And one thing that is important to consider when considering licensing of copyright, where there's going to be multiple types of copyright involved. So streaming services, obviously, you're going to have copyright in the content compared to copyright in the software that is allowing the streaming of that content. So in the ruling, both the current ruling and the proposed ruling, that will be dealing with software. Interestingly, it doesn't even necessarily engage in the fact that copyright needs to subsist in the software, it assumes that it will subsist in that software and just says this rule, the new rule is subject to software. And as I said, the content which is being displayed will then, of course, be subject to copyright and copyright licensing, so that the communication of that content is captured, because that artistic, whether it's movies or music, is treated differently to software. And whether you're watching it from your home and the content is being hosted, in a different country, you are having that content communicated to you. I think another important point to also think about when looking at different types of copyright and IP rights that are granted under distribution agreements is that if there's a broad right to granted to a distributor to sub-license any of the IP rights, which may include software, may not be needed for the software. It may be needed for copyright and marketing content. It may be needed for trademarks and other IP rights that may be captured in that distribution agreement. Is making sure that when looking at these types of distribution arrangements, is that each of those IP rights are clearly articulated as to what rights are required. So it's easily identifiable as to the rights which are attributed to the copyright in the software. And if there's no license necessary, not granting that license. But as Sarath mentioned earlier, also ensuring that, I assume they're going to be looking at substance over form, and that just because you've omitted to include a right to sub-license in a legal agreement may not mean that there's an implied license, because that's how both of the parties are acting. So I think it's important to keep that in mind also. Thanks, Neil.
Thanks, Rachel. This next one might be quite interesting, actually, and I might get Sharath to comment on it first, and then Rachel, I might get your views as well. But when we look at it in the context of data, what sort of thoughts does that bring up? I mean, clearly we dealt with copyright in the software, and we know, as we said earlier, at least in the Australian context, we look at the provision of information and source code would be captured. But thoughts around data? Sharath, you might like to comment first.
Yeah. So I think in terms of data, I would sort of apply the same principles as the Supreme Court has applied. Now, data can be off-the-shelf data, like it's standard data as a product which is given or available to anybody who wants to pay a price. So if you look at online database companies who do their research and put out standard products out there, and you have to just pay the dollars and buy it. Yeah, it's non-proprietary. Then in those cases, I don't think there is any use of copyright over the data. It's just productized data, I would say, that you're buying as goods in a way. And therefore, in those cases, there is no royalty. But the moment it becomes customized data, where it becomes customized information to suit the needs of the person who was requested for it, I think that's the gray area where it could amount to royalty, or it also could amount to services. So that's the area that one has to watch out for. But non-proprietary data sold as products, in my view, shouldn't amount to royalties.
Thank you. Rachel, what do you think? How would data be captured?
Could you just repeat the question? Apologies. It was cutting out a bit for me.
What do you think about the provision of access to data being captured?
I think the provision to access the data, if you're the distributor, wouldn't necessarily be captured by the software ruling. And it's important to also recognise that some data may not be captured as copyright too. So it's important to consider whether in fact there is copyright in certain data, in databases itself, whether it's access to data to run its own tests on, etc. So if it's not being downloaded, I think data's quite an interesting one because, you know, whether, as I said, how it's presented, how it's used, and whether copyright will actually subsist in that data. Is it, for example, created by AI, and in which case, you know, does it actually have an author and have the necessary characterizations for copyright to subsist?
Now you're getting into some really interesting areas when you bring AI into it. But I think it's an excellent point around, you know, is there copyright associated with the data?
Sorry to throw up some more complex issues.
That's a topic for next time. We'll probably go to another question. And if we look at it in the context of technical services, you know, where might these sort of things fit in? You know, if we're looking at India and Australia of themselves, it's an interesting question. And when you look at interactions between Australia and India, I think that's interesting as well. So, Sharath, I might just ask you about this one. What are your thoughts on technical services?
Yeah, so technical services, now if you look at the royalty definition, Neil, it says that if any service is given which is incidental to a transaction which is characterized as royalty, then even the incidental service would amount to royalty. For example, the break fix services or the updates and the patches that are sent could have amounted to royalty provided the main transaction of licensing of software for use itself amounts to royalty. Now, in the Indian context, since the Supreme Court has said that a mere licensing of software for just use doesn't amount to royalty, in my view, the AMC services or the updates and patches that are provided or some break fix services should not amount to royalty as well, because these are incidental to the main transaction of sale of software. Whereas in other cases where the software is customized and it's provided more like a solution, not off the shelf, and the source code, etc., is transferred to the user or the buyer, in those cases it could amount to royalty, or it could amount to fees for technical services. Most of the Indian tax treaties have, in addition to royalty article, they also have an article for fees for technical services. Look at the India-Australia treaty, for example, the royalty article itself captures fees for services. The only exception is that not all service fees would get taxed. Only those service fees which involves transfer of know-how or transfer of technology from the service provider to the user, only those will come within the article of royalty. So it depends on fact to fact. If it is a standard AMC or it's just updates and patches, those would not be subjected to royalty and no withholding tax. If it's more customized and there is transfer of know-how, and if it's more like a solution, then that is something which may come within the scope of royalties.
Agreed. And I think from the Australian context, similar. You know, these could be services that are ancillary. However, where it's the technical information that's being provided, that could bring it within the scope of the royalty definition. Now, the Australian treaties generally wouldn't have that article that you mentioned that's in the Australia-India Treaty. But the Australia-India Treaty, Article 12.3G, I think it is in particular, brings into play that technical service element. And obviously in Australia, we've had a case kind of dealing with this issue where it was held that such payments would be subject to royalty withholding tax, and it considered onshore, offshore sort of components to that. I think there are some more questions in the Q&A. What we'll try and do is get to them offline, given that we're just about out of time now. So thank you very much. This brings us to the end of today's discussion. What we'll do, as I said, is we'll try and respond to some of these questions offline, and we'll pick up from there. So Sharath and Rachel, thank you very much for your presentations today. A special thanks to everyone who's able to attend our presentation. We encourage you to fill in the short survey that'll pop up on your screen momentarily and tell us what you think about today's program. If you joined us late, please know this presentation will be archived and available for future viewing. If you feel others would benefit from the webcast, please share the webcast via the Share This icon or have them visit the Dbriefs website. As I said, we'll try and respond to all of the questions submitted during the webcast over the next week or so. And if you think of any other questions or comments later on, please feel free to reach out to me or our speakers directly, and we'd be more than happy to chat to you. Please don't forget to tune in to our next webcast from the Transfer Pricing series on the 7th of October, titled Customs Interaction with Transfer Pricing. At last, from all of us at Deloitte, thank you for your participation in Deloitte Asia Pacific's tax webcast today. Have a good afternoon. Goodbye.